Good afternoon, ladies and gentlemen. I first like to thank my learned colleague, Mr. Nguyễn Mạnh Dũng, for the initiative to organize the Arbitration Week, the first Vietnamese Arbitration Week, to celebrate the 10th anniversary of commercial arbitration law in Vietnam. And as part of the Arbitration Week, VAW and the Society of Construction Law of Vietnam jointly present to us the very wonderful program today. So we will, in this session, we will try to explore how the construction industry resolve their dispute and which forum they choose. I have the honor to be at the same panel. Actually, it's not the same because we joined virtually from three different continents, but we are still the same panel. Joining with me today is Professor Thomas Stepanovic. Can I call you Tom?
Please.
Yeah, please. Professor Tom is a leading authority in arbitration construction. Mr. Kevin Nash, whose name is well associated with the success of SIAP. So we are very lucky today to have the two experts in the field to talk about the reasons why ADR is chosen as a preference over litigation for construction dispute. So and myself, my name is Jin Nguyen. I'm one of the first three fellow of the SIAP, Charter Institute Arbitrators in Vietnam. So today I will wear the hat of the narrator to narrate the conversation between the two parties, the two experts, to discover why arbitrations and ADR are chosen as a preference in construction dispute. So let me just take you through the nature of the construction industry. You know, in the construction industry, disputes are inevitably because the nature of the work. Everyone working under time pressure, and also to meet the deadline, to meet the schedule. Who are the parties in the construction site, and who may bring the claim against who? Actually, they are the parties working together on the same site, but they also, their interests are not always opposite, but their interests may be sometimes interdependent. No matter what complex the matter is, the dispute in construction industry evolved around the number of claims, typical claim, the claim for extensions of time, the claim for variation, the claim for the claim for liquidated damages. So because of the nature of the dispute, so the way the party choose the forum to resolve the dispute also reflect their mindset. I believe that Tom has written extensively in this area. So maybe Tom can share with us the mentality, the rationale, why the parties to the construction industry choose the forum. Over to Tom.
Certainly. Let me begin by thanking VIAC and the Society of Construction Law of Vietnam on this august occasion. I'm really honored to be with you, and I thank you so much for including me. You know, I think it is an established fact that construction parties often regard courts as anathema. Certainly that is true in my country, because they recognize that so often when you get into protracted, extended litigation and adversary process, it makes disputes worse. It leads to a spiraling of conflict. It can derail a job. It can undermine the business goals of parties. Therefore, the construction industry and parties to construction projects have constantly looked for alternatives. And for generations, a leading alternative has been arbitration. There are a variety of reasons for this. One, of course, is just the basic concept of choice. There are many specific reasons why parties might choose arbitration in a specific situation. But I think the most important aspect to put first and foremost is the whole notion that you have choices. When you go into arbitration, it's not a one-size-fits-all process. It may be tailored to the needs of the parties. I don't think this can be emphasized enough. Now, in the case of construction arbitration, to me, the single greatest opportunity that construction arbitration provides is the choice of expert decision makers. So often when we think about going to court in the United States, we recognize that people are often chosen not because of their expertise or because of their knowledge of areas of conflict, but because of their ignorance. So in arbitration, we have the opportunity to select expert decision makers. In addition, you have the potential for an efficient, cost-effective dispute resolution process. That is not always the primary goal, but it is very often a leading goal of parties to construction cases. Also, there's the opportunity, in addition to having a process that is more effective, you may have outcomes that are more in keeping with the expectations of construction parties. By having experts, not just with legal expertise, but with other kinds of professional or construction expertise or design expertise, you have the opportunity to really do a better job of grasping what the contract really requires. Also, another aspect of arbitration that I think has been discussed more and more in recent years is the privacy and confidentiality that the process affords. Finally, there are two really important aspects of arbitration in the international arena that I think can't be overstated. One is the ability to avoid another party's court system and to have a level playing field upon which parties can come together on a relatively neutral ground. And also, of course, as we know, under the New York Convention and other international conventions, we have a system of international enforcement among the more than 160 countries that have passed the New York Convention. So those are certainly all key factors why parties may decide that arbitration is preferable to litigation for adjudication of construction disputes.
Thank you, Tom. I think that what you say is very true about the ability to enforce the award. Across the countries, across the border, like if you have the judgment, then when you want to enforce the judgment in another country, it could be a nightmare, because a lot of country may not be recognized the foreign judgment. So in that, to that extent, arbitration, of course, have the advantage over litigation. I also heard that you touched upon the party autonomy. Like you talk about choosing the process of choosing expert, right, choosing the person who make the decision. Now, I am not even the expert. So I think that with that point, I would like to ask Kevin to share with us whether in the context of Singapore, I understand that in Singapore, the judge, there is a special court called commercial court. And in the case of the UK, there's some, the court called High Technology and Construction Court. In the case of Vietnam, we don't have the special court for construction. We need to go to commercial divisions, but then it depends on whether the judge has the expertise on the construction. But in the context of Singapore, even when you have the Singapore court, Singapore commercial court, you think that there is competition between the arbitration and commercial court? Or you still have the advantage over the litigation?
That's a great question. I can remember in 2014 when they announced the Singapore International Commercial Court, a lot of arbitration practitioners and arbitrators were concerned that this might affect the popularity of arbitration. In fact, in Singapore, it has done quite the opposite. It has only enhanced the suite of dispute resolution services in Singapore. What we effectively offer for international parties in Singapore is you have three pillars of the dispute resolution system. So you have the Singapore International Arbitration Center for international arbitration. You also have ICC, WIPO, SCMA, ICDR, all administering cases out of Singapore. So that's the international arbitration component. You also have the Singapore International Mediation Center for international mediation, and then the Singapore International Commercial Court for international litigation. You can see by the composition of the bench of the Singapore International Commercial Court, most recently with Professor Doug Jones from Australia, that it is populated with construction experts. So you can be confident when you're going to the Singapore International Commercial Court that you are getting a construction expert that's hearing this case. Singapore has also clarified that applications in support of arbitration may be the Singapore International Commercial Court. So you have the Singapore High Court that is already arguably one of the most pro-arbitration courts, but if an international party is more comfortable and wants to make an application to the Singapore International Commercial Court, where there's a bench of international jurists for the support of their arbitration, that is also available. So the system really works together, and I think as arbitration practitioners, as institutions, we want to be humble to the degree to not think that one type of ADR is suitable for all kinds of disputes. But I think overwhelmingly, and particularly with the caseload at SIC, in these multi-party, multi-jurisdiction construction disputes, the choice is international arbitration.
So good to hear that not even the competitions of the Singapore's commercial court undermine your business, if I call it business, but also offer the choice for people to come to Singapore. But then maybe you can share with us what is the feature, the unique feature of arbitration proceeding versus the commercial court, that will enable you to tailor the process. For example, emergency arbitrator or early dismissal.
Yeah, and yeah, that's a very good question, and it's exactly as Tom said, that arbitration is ultimately a party-driven process. So you have these sets of institutional rules, but the first principle of arbitration is that parties are able to customize the process. What I think that we're seeing to a certain degree is that arbitration is adopting some of those features of litigation. Trin, you mentioned early dismissal. That is effectively the incorporation of summary judgment and striking out into arbitration. You look at some other features such as consolidation and joinder. Again, we see this from the litigation process. This has been brought into arbitration. And this is particularly important for construction disputes. Let me give you a quick example on how important consolidation is and how it might vary across the different sets of institutional rules. You might have a dispute with an owner and a contractor, and then a contractor and subcontractor, and a long chain. And say this is arising out of 5 contracts or 50 contracts. One of the advantages of SIC is for consolidation, you do not need these to be the same parties. So you could have claimant A and respondent A under one contract, respondent A, respondent B, claimant A, respondent C, and you can collapse these all into one proceeding. So this is critically important for construction disputes, to not have to have separate proceedings. So SIC is somewhat unique in not requiring there to be the same parties. There just needs to be the interconnectedness of the disputes. You also raise an important point of emergency arbitration in the context of international arbitration versus the court. Really, emergency arbitration is designed to work in a complementary way to court. So it does not preclude a party to an arbitration agreement from making an application to court. If it is put in the Singapore legislation, effectively, if the institution is not able to act. So if you needed an order against a third party, if you needed ex parte relief for any reason, or if confidentiality was not a concern, you can make this application, say, to the court in support of your arbitration. But what I do know is that there are very few, if any, courts in the world where you can make an application for the appointment of an emergency arbitrator at 1 in the morning and on a Friday night. And you can't do that at SIC, and it happens often. The most typical example that we see at SIC is an application late on Friday evening. There may be a call on a performance bond on Monday morning. What we're able to do is we're able to appoint an emergency arbitrator on Saturday. The emergency arbitrator might make an interim order on that same day against the call on the performance bond, and then say within 7 days, they're going to have the hearing proper. You can see how this would manifest in construction disputes. It could be preservation of evidence or assets, delivery up of documents, preventing the call on the performance bond, ordering access to a site. These are all reliefs that emergency arbitrator could technically grant. What's important to note about an emergency arbitrator order is that these are likely not enforceable under the New York Convention and are not enforceable per se. So you have to think about what you're going to do with this emergency arbitrator order. What we have found, very fortunately, is that parties tend to comply with these emergency arbitrator orders, and typically they are status quo orders. The emergency arbitrator just wants to keep everything the same, and then the tribunal can be appointed and actually decide.
Oh, so that is very good to know. That's very good to know. And the distinction between the emergency arbitrations and the normal proceeding. So maybe the parties may have the strategy. They may want to have the emergency arbitration for a particular claim, and then deal with the rest of the claim later on, or deal with the injunction, or deal with the bond, calling up the bond, something emergency.
Well, that's exactly right. Sometimes the test for whether the emergency arbitrator might grant the relief is if the relief is intertwined with the merits. The least complicated situation is a status quo order. Let's just keep everything the same and then go to the tribunal to decide.
And I overheard that the arbitrator who is called emergency arbitrators is usually experienced arbitrator and specialist in the area, right?
Yeah, exactly right. And that's one of the advantages that Tom was speaking about is in arbitration. So whether it's the main tribunal or the emergency arbitrator, you are going to get a specialist in this area. So you will have an emergency arbitrator who not only has knowledge of the governing law, the law of the seat of arbitration, but has this sector expertise that understands the complex issues in construction disputes and can make a really commercial decision before it goes to the main tribunal. So the ability to have specialized decision makers, is a fundamental advantage of arbitration and particularly important for construction disputes.
Yep. On that point, I would like to go back to Tom. I think Tom made a very interesting point regarding the expertise of the arbitrator. In your view, for construction dispute, what do you think that what is the best way to construct or to constitute the tribunal? It should be multi-discipline tribunal, which comprise the expert and engineer and lawyer. So over to Tom.
I don't want to say that any approach is always the proper one, but I will tell you that I personally tend to favor multidisciplinary panels. And I think it's important in some cases, for example, in my own experience, where you have someone with construction management expertise, has a real grasp of productivity rates, and other issues that may not be as significant for those of us whose primary focus is construction law. And one of the things that I think we have, at least I've seen in my practice, a tendency to concentrate on all lawyer panels. This to some extent may be a function of tripartite processes where each side picks their own arbitrator, and then they pick a third. And I think this has had a tendency to place the emphasis on all lawyer panels. And I would simply suggest that this is not always the very best solution. That three lawyers is having a three-lawyer panel without other expertise in some cases may be like having trying to paddle a boat with all of the paddles on one side. So it's and what do? You go in circles. But anyway, the fact is,
one can argue that the arbitral tribunal may rely on the experts that they can appoint themselves or the party appointed expert to guide them through the law. But anyway, that is the
well, yes, that's a whole other party appointed experts are a whole other story, and I think a source of contention. Party appointed experts raise their own issues. So I think it's certainly a subject for discussion. What is appropriate in a specific case? I guess I would say that my own view is that all lawyer panels may be overused. Would never say that all lawyer panels are inappropriate per se. I think that they may do an excellent job and they may be exactly what the case needs, but then again, they may not.
We are conscious of time. I don't know how much time do we have. I know that there's a lot of things that we can discuss. John, can you please tell me how much time do we have left?
We have 3 minutes, Chin. We have 3 minutes.
3 minutes?
Yeah.
3 minutes?
Yes, 3 minutes.
Oh, or 3 minutes left. So in such a case, I just quickly pointed out, I just want to touch upon what Kevin talked about, the way the arbitrations inherit from the litigation and try to design and tailor it. Maybe you can reflect it in the way that the expert conference and expert witness statement, picking up on what Tom just said, and quickly pointed out whether on arbitration, on construction disputes suitable for arbitrations.
Okay, I will. It is a big topic. We often say that SIC is the fastest institution in the world, so I'll try to give the fastest possible answer. Obviously, exactly as Tom said, experts feature often in construction arbitration, particularly on issues such as loss and quantum engineering standards, analyzing schedule delays, forensic accounting, root cause of defects. These can be party-appointed experts or tribunal-appointed experts. Most often, it is party-appointed experts, but this is also going to shape the arbitration proceedings. What we often see and can be efficient is you might have 3 phases. It's trifurcated. First phase on jurisdiction, second on liability, and then the third phase, for instance, on quantum. So experts, certainly a very common feature of construction arbitrations, particularly, say, the very large multi-billion-dollar disputes.
I know that we are conscious of time, but I also like to give the audience the benefit of hearing from the 2 experts the other side of the coin of the arbitration. Some quick outline of the pitfall of arbitration, why it doesn't work. Maybe Kevin first and then Tom. And with that, we can conclude this session.
Even more quickly, you have to make sure the arbitration clause, everything turns on that. Make sure you've drafted the arbitration clause properly. You can avoid all sorts of problems. So that would be, I think, the fundamental and quickest answer.
Quick. Thanks for the tip. Tom, please.
All right. You heard Kevin mention the importance of preparing, laying the groundwork for a resolution of multi-party disputes. That requires a lot of prior planning to do it properly. And that is one place where arbitration can go astray if you don't have proper rules and the proper arrangements in the respective contracts. One other thing I'll just say in 2 words: litigation mindset.
Yeah, that is a very good conclusions. But on that point about the multi-step, multi-phases arbitration agreements, I think let's give the credits for the mediation step. Sometimes people don't tend to understand or appreciate the value of mediation before going to arbitration. But I think with the met-up mechanism of Singapore model, I think that would give the party the psychological preparation and put them back to the state of negotiation and interest-based negotiation rather than position-based negotiation. With that, I think that we have done really well. I thank so much Tom and Kevin for wrapping all of the issues within 30 minutes. We've done well. Thank you so much. I'm honored to be at the same panel with you. Thanks.
Thank you, Kevin and Tom, for the first session, fireside chat. Quite a good session. Industry prefer idea over litigation. So the next one, we will listen to Thomas regarding the American perspective on arbitration and other idea methods for concession dispute. Tom, can you start sharing your screen and start your presentation?
Yes, I will. Thank you so much.
Okay, we can see your screen well.
Okay, 1 second. All right, can you see the slideshow?
Yes, we can see.
All right, very good. Really briefly, what is it that construction clients want? They want to make a profit. They want to complete projects as efficiently and expeditiously as possible. They want to maintain good business relationships, and they seek fairness, efficiency, and certainty in the handling of conflict. Now, in the United States, I'm speaking on US perspectives here on construction conflict management. As I mentioned before, litigation is a part of the landscape, but a more preeminent way of adjudicating is arbitration for all of the reasons that we noted before. Here are some of the reasons that construction companies, design professionals, and owners say they use arbitration. Efficient and cost-effective dispute resolution. They want something that comports with applicable law and industry standards. They want fundamental fairness. They want to get on with business. They want a quick resolution, and they want a degree of control. These are all things to think about. Now, we talked in the last panel about the importance of choice. And we know that too much choice is as big a problem as no choice at all. But it is important to some degree to look at key choices that your client wants to make with respect to arbitration. So for example, if our primary interest is in a process that is as efficient and cost-effective as possible, we may want to consider a streamlined process. And you are seeing a number of major providers, including the American Arbitration Association and JAMS, publish expedited or streamlined procedures, both for domestic use and for international use. Obviously, there are a lot of other possibilities, using a single arbitrator, training arbitrators to be as proactive in their management of the case as possible. You heard Kevin talk about opportunities for summary resolution of disputes. This is something that right now is becoming much more of a focus in arbitration. These are all ways of trying to come to grips with and effectively manage disputes to move them forward as quickly as possible in arbitration. Another thing we've observed in American arbitration is that this is based on a survey we did of many of the leading arbitrators in the United States. There is a higher rate of settlement in recent years than there was in years previously. More likelihood that a conflict is going to be negotiated to a settlement during the arbitration, or at least before an award is rendered. And finally, there may be a concern, as we hear sometimes, about ensuring fairness and certainty. Here again, I think there are a variety of things that might be done. One issue that sometimes comes up in the United States, and not so much internationally, is the role that party-appointed arbitrators are supposed to play. Believe it or not, in the United States, party arbitrators may be partisan toward the party that appointed them. Now, this is not the case under most leading rules. However, there is some concern about this possibility. Another thing that is a feature of the US system is the notion of appellate arbitration. You can actually, in the rare cases where someone wants a second look at an arbitration award, leading providers have some form of appellate that is a second level of arbitration. Now, very early in my practice, I had the wonderful opportunity to be involved in one of the first major construction mediations in the United States. And this was back in the early 80s, about 30 years ago. And mediation has really come to the fore. And I want to talk, there are many, many topics we can discuss here, But I do want to touch briefly on mediation and why it has experienced such huge growth as an engine for resolving construction disputes. We asked a group of lawyers, what is it? What are the functions that mediation performs? Look at all of these phrases or words that reflect what mediation does. Cost savings, efficiency, giving parties a voice, coming up with better outcomes, saving money, empowering the parties to work together better. You know, I like to tell my students and practitioners that we train that you know, the law and adjudication, arbitrators and judges have to look at the legal and factual and technical issues. It's a rights-based process in arbitration or in litigation. But in mediation, we have the opportunity to go below the line, below the surface, to look at all the drivers of conflict, business and personal priorities, interests, emotions, values, things that may be really, really critical. Facilitators have special skills and special abilities to be able to work with parties, to develop trust, to develop rapport, and turn that rapport into an ability to help the parties reach a resolution. Typically, mediators are, in the United States, are masters of process as well as substance. So there may be a whole variety of things you can do in mediation in terms of process. They're very deliberate about the kinds of techniques they use. They can look for trade-offs, and they can be even-handed in their interaction. And of course, they have the opportunity to conduct private caucuses. Now, we could talk a lot about mediation approaches. We don't really have time to get into that today, but let me just say that mediation has come to the fore as the primary basis for negotiated resolution of construction disputes. In fact, a lot of US lawyers don't like to negotiate without a mediator. Let me show you a couple of charts. Here, and I'm not going to try to dwell on this in detail. You'll have an opportunity to look at it later. But what this chart demonstrates in the red portions of these columns is the impact that mediation has in achieving construction companies' business goals. And what's extraordinary about this is the wide range of things that can be accomplished with mediation. And this is a much broader range of possibilities because you have the opportunity to tailor a resolution based on party interests, as opposed to simply having a limited scope of remedies, which both courts and arbitrators have. I thought this was interesting. We asked these corporate counsel for construction and design firms, what is it that you want to put in a dispute resolution provision in a contract? There are three major components. And Trin was talking about stepped or escalation provisions in contracts. Typically, arbitration does not stand alone. It is a multi-step, multi-lane process, not necessarily linear, although that's often the way it's laid out. Notice that these corporate counsels said, we like to have a provision for project level settlement discussions. Right in the project, we want to have executive level meetings where we can kick the negotiation upstairs to senior management and have them resolve it if it can't be resolved on the job site. We want some kind of mediation, preferably mandatory mediation, meaning the parties are required to mediate at some point. They're required to come to the table. Although I will tell you that lawyers debate this point, and we could talk more about it if we had time. Finally, if you compare arbitration to litigation, these lawyers say when it comes to adjudication, they very much prefer arbitration as a rule. But what you see here is that this is a multifaceted set of tools for resolving conflict. and arbitration is simply one of them. What you see here is that, again, I will simply describe it, and you can look at it later. Many of these people said that their primary method for resolving conflict is project-level negotiations, because that is the best way of coming to grips with conflict and preventing it from spiraling into a legal dispute. They also have an extensive array of experience with mediation, followed by forms of arbitration. So, and not only do they have a lot of experience with those areas, but we also discovered that they had a great deal of success with project level negotiation, with getting a mediator to come in and help with negotiation and forms of arbitration. They would prefer that in general to other alternatives such as going to court. So how do we make the most of mediation? There are a whole variety of ways of mediating. If we had more time, we could talk about that. Today, preparation is more critical than ever. I have a mediation in a construction case with multiple parties coming up in early July. And the parties are sending me some materials, but to me, the most important element of the mediation is what happens before I bring them together. Because I talk with the lawyers, I learn about the history of the dispute, I learn about the personalities of the parties, and I talk to them about all aspects of the matter and how it might be resolved, and we design a mediation to address that. I use a variety of techniques, as do other mediators in the United States, in the course of resolving disputes. I may focus on process issues, and sometimes I've actually helped the parties work out a form of binding arbitration to resolve the dispute if we can't get everything mediated to a resolution. And of course, there are a variety of ways of handling individual disputes. Now, here's another chart that you can look at when you have more time. I will simply say to you that this indicates that mediation may be used at many different times. There's always a possibility for negotiation or a mediated resolution. It could be during the project. It could be after the project, but before arbitration or litigation. It could be during or even after arbitration or litigation. There's always the opportunity for using it. I want to just put this, maybe like me, some of you think graphically. I was an architect by background, and I think I still think in terms of pictures for a lot of things. But I want you to imagine a chronology of a conflict, beginning with an issue. Then at some point, an issue on a job site becomes a dispute. Later on, the lawyers become involved, which itself transforms the nature of the dispute. And finally, you have, in many cases, third-party adjudication, either arbitration or litigation. Now, level of conflict. What happens to the level of conflict as we go along through these phases? The level of conflict increases tangibly with each successive phase here. Similarly, the amount of cost and time that is spent increases. Now, from the standpoint of party control and ability to affect an effective resolution, that goes down. Party control becomes less and less, and finally, relationships tend to be harmed in this way. Now, if you think about it, where does arbitration occur? That occurs way up here at the end. And arbitration is a very important element in dispute resolution because it is so effective in many cases, and often it's the only way to resolve a conflict. However, we have learned in the United States that mediation, often in some of the latter phases, will be a more effective way, a more flexible way, and a more satisfying way to disputes. I'm almost finished. The other thing to think about, though, is it's possible that you can resolve disputes in real time on the project, during the project, before disputes really take off and acquire a mind of their own, if you will. You can bring in a real-time facilitator, a mediator, a role that a number of us have played, or of course an evaluator, like a dispute review board or dispute adjudication board. This may produce resolution of a dispute, or it may actually avoid a dispute. It may actually permit the parties to resolve things. And notice, if you resolve it early, all of the costs that you avoid, all of the negative elements that you avoid. If this can be done, it is a great success. And of course, as I mentioned, in addition to real-time mediation, project mediation, on larger projects, infrastructure projects, as many of you know from World Bank projects around the world, dispute review boards or dispute boards are a very important element that can be brought to bear as well. I want to end with one more example. That's a fairly recent program. And it's really a step forward from typical stepped conflict management in the construction arena. You all know the company Intel. Intel has a very large capital construction program. They have projects all over the place. They have recently developed a custom program for dispute prevention. They bring in embedded neutrals who are engaged by the owner and general contractor, people with extensive professional construction expertise, conflict resolution experience, communication skills, etc. They develop relationships during monthly visits with a risk management team, people from the stakeholders in the project. They assess job progress and risks, and they consider appropriate options for resolving disputes that arise. Often they can help mediate a resolution, and thus far, they have never had to go above the negotiation phase. They've never had to use third-party intervention strategies other than the most basic negotiation. So here is an example of moving upstream and managing conflict at its roots. Well, I think I'm just about out of time, but I hope this has given you a sense of the multifaceted nature of dispute resolution and conflict management in the United States. Arbitration is a very critical element of it. Mediation has come to the fore. Forms of non-binding evaluation, including real-time processes, are very important. And now we have active project management as well. So I'm going to end the share.
Yes.
And I hope that this has stimulated some thinking, and I will, if there's time later, maybe I can answer some questions. Thank you so much.
Okay, thank you, Trọng. I would like, before we start with the next speaker, I understand that Trọng will let the desk, and also Chin and Kevin. So I would like to raise, give the audience two questions. Chin, can you start with some question already on the chat room? Unmute Chin, please, unmute. Okay. Unmute, okay, right.
I have two questions. One questions in the audience here.
Yeah.
It is about the difference between the VAW decision and the mediation process. And I already have preliminary answers during the in the chat box. But maybe I start first, and Tom could try to help me. I believe that DAAP is the process where the experts where the panel of experts to make a decision, and that decision is not enforceable, that doesn't have the we at least in Vietnam we don't have the regulations that enforce that decision, and I believe in other jurisdictions that may be another problem, but usually they hope that when the decision come from the VAW board, the parties will voluntarily comply with it. Mediations process is the process where the mediator facilitates the process of negotiation between the parties and cannot give advice or make any decision or suggestions or opinion, but can facilitate for the parties to come to the conclusions or agreement. Of course, they can use technique. Two other feature the difference from mediation, especially in Vietnam context, is the mediations settlement agreements is confidential and cannot be used as an evidence in court or in arbitration later on. And the settlement agreement mediated by a licensed mediator registered at the Department of Justice or at the mediation center, a licensed mediation center, could be enforced, could be recognized by the court and enforced. That is from me.
I'm so glad that you clarified the basic distinctions, Trin. Let me, if I might add one thing. The concept of mediation, as you describe it, is essentially, I think, fairly universally understood, and that is that the mediator facilitates a negotiated resolution between the parties. So the mediator is not adjudicating, but is helping the parties reach a negotiated resolution. How active the mediator is, and whether the mediator is directive or simply or does not offer opinions, that's a subject of quite a bit of discussion among mediators and practitioners internationally. And in some countries and in some regions, mediators do not evaluate, do not make recommendations, but in other places they do. So I think in international practice, it's important to understand that there are different perspectives on what mediators do. And if we had more time, we might be able to get into that some more.
Can I add one more thing on that? Many people have the opinion that the mediator may not need to have the expertise in the field, in the area, or in the industry. On the other hand, some people think that the mediator who has the expertise or the background may be able to understand the process properly and can steer the process properly. Of course, with the, like unconscious bias or something like that, we will have to watch about that. But as you said, the activeness of the mediator also another issue, because if you don't, you just simply ask the question, and the question must be in the direction that the people can understand and can evaluate their own options. Maybe we say the option, the alternative, the better, the worse now. So that is, I think that it depends on the style of the mediator as well.
Yeah, right. Thank you very much. Thank you, Chin and Tom. Maybe Kevin already left. So thank you very much for your session. Okay, now I would like to invite Donald Charest to present on the Australian perspective on arbitration and other idea matter for conjunction decree. Donald, please share your screen. Thank you very much, Tom and Chin.
Thank you very much, Trung, and thank you very much to VIAC and the Society of Construction Law of Vietnam for inviting me to participate in this. Like Thomas, I am very honoured to be here and to be able to share this session with you. Now, I've prepared a PowerPoint, which I shall go to, and we'll go through a few slides.
Okay.
So, as Trung mentioned, I'm talking on Australian perspectives on arbitration, and I'll briefly look at some other methods of ADR for construction disputes. These are the topics that I will cover briefly in the next 20 minutes. Let's start with construction disputes. What are the distinctive features?
Donald, can you share your screen? Not yet share your screen, please. Not yet.
Sorry, what was that?
We not yet see your screen. Can you share your screen, please?
Oh, I thought I'd done.
Okay. Okay, thank you. Now it's go.
Sorry about that.
Yeah, good.
Let me just go back one slide. The topics that I'll discuss briefly are there, starting with the particular features of construction disputes. I think these are the sorts of things that we've already heard a bit about, but make construction disputes quite different to a lot of other commercial disputes. For one thing, projects typically extend over a very long period of time. There are very often complex and extensive contract documents involving both legal documents as well as technical documents. It's now got to the point where in Australia, for big infrastructure projects, the parties are given a hard drive with all the contract documents on it because they occupy many lever arch files. Because projects go for such a long time, there are very extensive documentary project records. And it's often said that disputes are almost inevitable on construction projects. They typically involve one or more of the following. Perhaps a legal entitlement, such as whether an employer's instruction is a variation in accordance with the contract, or if you think about the disputes that we've probably all heard about already during COVID, is the interruption to project work a force majeure event or not? Ultimately, certainly in our common law world, that comes back to a legal question. Time, is the contractor entitled to an EOT? Cost, what are the cost consequences of delay? And quality, which is a very common one, is the contractor's work defective, for instance. The factual evidence often involves quite complex technical issues, and as we've heard, expert evidence often required and is frequently controversial. So just looking then at what is involved in ADR in Australia. As Thomas was talking about the number of different techniques that are used in America, I guess very similar in Australia. And I think any significant construction dispute involves typically a ladder of increasing cost, complexity, formality. I haven't put on there, but usually it does start with negotiation at the project level, followed by negotiation between senior executives if it can't be solved on site. Mediation is, I would say, almost universal for construction disputes in Australia, and certainly if a dispute goes to court, it's a precondition. Generally, you won't get a court hearing in Australia for a construction dispute unless you've at least tried mediation. Then we have another method, what's referred to as statutory adjudication. In Australia, this is confined to cost disputes. We borrowed the concept from England, which uses adjudication for all construction disputes. We confine it to cost disputes only. It's governed by state and territory legislation. It's all about trying to decide who gets to hold the money, pay now and argue later, but it doesn't finally determine legal rights. And often these adjudications involve disputes over quite large sums of money, sometimes in the tens or more of millions of dollars. Interestingly, I think there's more disputation in the courts about enforcement or whether the adjudication is valid under the relevant acts than there is in terms of ultimately arguing about the legal rights on the disputes. We have dispute boards which are used extensively for major infrastructure projects in some of our states, and I'll talk briefly about that in a moment. We also have expert determination, which is perhaps a form of adjudication or almost a mini arbitration, but generally less formal, but certainly involving an adjudication on legal rights. And then, of course, we have arbitration. In Australia, dispute boards usually, well, I think invariably, appoint at the start of the project and meet regularly with parties during project execution. They're called DABs in Australia, which stands for Dispute Avoidance Board, because their primary function is dispute avoidance. This is achieved in various ways, and I often like to draw a parallel, I think, with mediation, because I think the skills of a good DAB really need the skills of a mediator to be able to get the parties to talk together and, if possible, come up with their own solution to a problem, or, if necessary, if a formal dispute is initiated, then provide a rapid, cost-effective determination based on legal and contractual requirements. But there are those steps before that, informal advice and also perhaps an advisory opinion on a without prejudice basis, a quick and dirty, if you like to use the expression, view of what the resolution of the dispute should be. The history of these boards in Australia has actually been very good in that very few have had formal disputes to actually determine, and none of them have actually gone beyond the dispute board to go to arbitration. So moving on to arbitration. In Australia, we're a federal country. We have 6 states and 2 territories, and the Commonwealth Government passes laws that relate to our international rights and obligations. So the Commonwealth Act of the International Arbitration Act is the one that governs international arbitration. It gives effect to those 3 things I've mentioned there. Australia's obligations under the New York Convention, that is on the recognition and enforcement of foreign arbitral awards. It gives effect to the UNCITRAL model law, and it also gives effect to the ICSID Convention on the settlement of investment disputes and nationals of other states. So in terms of recognition and enforcement, where there is an arbitration agreement that satisfies Section 7, that is the New York Convention. A court must stay court proceedings and refer the parties to arbitration. So if there's a valid arbitration agreement in place, parties can't circumvent that by going to court in Australia. The court will stay any court proceedings in favour of the agreement of the parties. Courts may make interim orders in respect of property, but that is in support of arbitration. Very few reasons for the court not to refer a dispute to arbitration, but they won't stay litigation if they find the arbitration agreement is null and void, inoperative, or incapable of being performed. Those of you who are familiar with the New York Convention will recognise the terminology. And of course, a foreign award may be enforced by a court as if the award were a judgment or order of the court, and they'll only refuse enforcement on those limited jurisdictional procedural grounds. The UNCITRAL model law has the force of law in Australia, subject to specific explanations, clarifications and amendments. I won't go into these, I've listed them there, you can have a look at them, but in principle, the UNCITRAL model law, which is very widely used around the world, has the force of law in Australia, subject to a few additions and a few minor deletions. We have some additional provisions in relation to confidentiality because the law in Australia, in the absence of those, is not entirely clear that arbitrations would definitely be confidential. So those provisions have been added to put the matter beyond doubt. And then there are a number of provisions in relation to procedure and, importantly, some miscellaneous provisions such as Section 28 that gives an arbitrator the same sort of immunity that a judge has in court proceedings. Then if we look at domestic arbitration, as I mentioned, we have 6 states and 2 territories. In many things, those 8 jurisdictions have quite different laws. This is one of the few cases where they have actually got together and the laws are, whilst they're not identical, they're in substance the same. They date from around about 10 years ago. They're as uniform as possible with the UNCITRAL model law. There are certain changes to amend or supplement the provisions for domestic arbitration. And of course, the drafting style is a little bit different. There are some additional provisions, which I'll look at briefly. Interestingly, the paramount object of the Act is to facilitate the fair and final resolution of commercial disputes by impartial arbitral tribunals without unnecessary delay or expense. And that unnecessary delay or expense, I guess, is one of the primary focuses on arbitration in Australia. It is subject to the often valid criticism that it looks far too much like litigation and it borrows far too much from the procedures of litigation, and in some cases can be more time consuming and more expensive than litigation. There are certain types of disputes that, construction disputes in Australia that where the acts prohibit arbitration, for instance, domestic building contracts. Interestingly, Section 18 requires that each party be given a reasonable opportunity to present its case rather than a full opportunity. And you can see that that is putting into effect that requirement to try and have a cost-effective and expeditious process. There's a listing of the new sections that are not in the model law. You'll see that most of those are additional provisions in the International Act as well. The ones in red are in addition to the International Act, so they are in the state legislation. I won't dwell on these. You can look at them if you're interested. A brief word on Australian arbitration practice. Small matters may well be decided on the papers without a hearing, but large matters, hearings are normal. Whilst, as I've mentioned, our arbitration procedure has borrowed quite a bit from court procedure, and I guess some of that is perhaps because lawyers are familiar with the way things are run in court, but we do have in some of the states specialist courts that deal with technical matters. We have a tech list in Victoria, Technology, Engineering, Construction Court, which we've had for 30 or 40 years, and they have been at the forefront of modernising the processes for court proceedings, and they've certainly been followed in arbitration. So, for instance, rather than each party, one party presenting all its case followed by the defence, it's common now for all oral lay evidence to be given before the expert evidence. There are often strict time limits on hearings. We call that stop clock, chess clock arbitration. As I mentioned, parties only required to be provided a reasonable time to present their case, and that challenge, which is probably there for arbitrators in every jurisdiction, to constrain the time and cost of an arbitration. And lastly, a few words about expert evidence. In Australia, party appointed experts are the norm, briefed by lawyers acting for the parties. Some of the legislation in some states has tried to promote single experts, but I think at this point it hasn't really been a big success. I think lawyers typically prefer to brief their own experts. But then what usually happens in Australia now, after the exchange of expert reports and reports in reply, the experts might be required to meet and produce a joint report, identifying the issues on which they agree and those on which they disagree, with reasons for their disagreement. Those joint experts conference, sometimes referred to as a conclave, may have an independent facilitator to identify issues from the experts' reports and assist in the preparation of the joint report. And then in the hearing, the evidence is usually given concurrently, and this is often referred to as a hot tub. I think expert evidence is certainly one of those areas that needs continuing focus on trying to make it more efficient and cost effective. The nature of construction disputes is such that expert reports are almost inevitable. They're often extremely expensive. And I think one of the potential problems with the traditional way of having experts briefed by the independent lawyers, the first reports that are produced sometimes are a bit like ships passing in the night. They've been, each expert has been given a different brief, different factual assumptions, and there's then the expensive process of reports in reply and perhaps the joint report. I think there's a lot of opportunity to make that process a lot more cost-effective and efficient. That's all I'd like to say at this point. So I'll come back to the video if anyone's got questions.
Thank you very much, Dongan. I think that maybe let Dr. Nate to start with Donald and you and Nate to start with the fireside chat, because we already have a few minutes late, and the question and answer will be skipped until later. Is it okay?
That's fine.
Yeah. Annette, can you use on? Okay. Unmute. Okay.
Yes. Yeah. Thank you very much, Mr. Nguyễn Nam Trung. Thank you very much, Mr. Donald Charette, Professor Donald Charette, and Mr. David Brown. It is my great pleasure to be the moderator to the next fireside chat. It's about the civil law versus common law construction arbitration. We have two distinguished guests here. I'm very lucky to be appointed to introduce to you Professor Charette and Mr. Brown. Dr. Charette is the expert determination chambers. He's an international renowned and a leading name in the region, offering clients over 30 years of engineering experience alongside with his legal expertise. Dr. Charette practices in construction law as a barrister, arbitrator, mediator, and member of dispute boards. He's a member of FIDIC President List of Adjudicator. And prior to becoming a lawyer, he worked as an engineer over 30 years. Dr. Charette has published widely on legal and engineering subjects and presented papers and training at numerous conferences. He's an author and co-author and editor of 5 books on construction laws. That is the Dr. Charette that you have just, we're just lucky to listen to his presentation. And the second speaker is Mr. David Brown. David Brown is a very experienced and distinguished partner of Clyde & Co. It's one of the leading law firms in the world. David joined the Paris office of Clyde & Co. in 2010 and has a wide range of experience of international construction and dispute resolution matters in 5 continents in many sectors of energy, infrastructure, and utility industries. David's dispute resolution experience notably involved international arbitration, particularly under the ICC rules that you will hear after this chat about ICC arbitration, as both counsel and arbitrator concerning a broad range of commercial matters in addition to construction. He features on the FIDIC President List of Adjudicator as well as the FIDIC French National List. David is listed as leading construction lawyers and Who's Who Legal and one of the top 3 specialists in France. He is recommended for dispute resolution in a European network of legal experts and also featured as recommended practitioner in PLC cross-border construction and project handbook for high-end international projects. So please join me to welcome David and Donald. May I call you David and Donald?
Of course.
Absolutely.
Yeah. Thank you very much. So our topic is about the civil law versus common law arbitration, construction arbitration. And the question might be rephrased as, is there still a significant difference in the approaches of the common law and civil law, especially when it comes to international construction arbitration? I would like each of you give your point, your viewpoint. Thank you.
David, would you like to start?
Very kind of you, Donald. Thank you very much. Thank you very much for those kind words of introduction, Ned, and my thanks to the organizers. I'm very pleased and honored to be able to take part in this event. Now, on this topic, since Donald is a real common lawyer, if he allows me to put it in those terms, I should mention that I am both an English solicitor and a French advocate. I've been a French qualified lawyer for 30 years, so I shall play up more the civil law side of this to see to what extent there really is a difference. The answer which I would give is that an answer that a lawyer gives to many questions. It depends. Although perhaps to start off, I would say that what we have seen over the last 20 to 30 years in particular is that there is a real increasing harmonization around the globe, especially between common law and civil law practitioners, as to how to go about arbitrations. For me, there are 3 or 4 particular reasons for this, and Donald may also have some ideas on this, but my thoughts are that what we have for construction arbitrations in particular is they tend to take place under a limited set of international rules, ICC, Singapore, Hong Kong, LCIA, that are increasingly similar in content. Then you find that, yes, you have construction arbitrators, or the arbitrators come from a wide range of backgrounds, legal, cultural, etc., but they all tend to follow the same sets of rules or guidance. For example, the IBA rules on the taking of evidence in international arbitration. And now when it comes to document production, we have things called Redfern schedules, which seem to have taken over the world. So, and then when you come to the arbitration parties, and particularly their lawyers, they seem to be happy to a large extent to follow what are elements of international consensus. Perhaps if hand back over to Donald, see if he has any thoughts first before I come back to 1 or 2 more recent initiatives that seem to raise questions about this consensus. Don, what do you think?
I agree with you, David. I think as with construction law itself, I think the differences between the way arbitration is run in civil law and common law, well, if we talk about international arbitration, I think there's a number of factors that lead to this increasing harmonisation. Let's start with the fact that we've had the New York Convention on recognition and enforcement of arbitration awards for over 50 years, and it's now in place in over 160 countries. The UNCITRAL model law on arbitration has created a great deal of harmonisation around the world. At recent count, there are over 80 countries who've implemented that model law. And then I think in talking about construction arbitration, we also have the fact that FEDIC contracts are the most widely used around the world, and a lot of disputes that arise do have or are based on FEDIC contracts, and those contracts themselves, I think, have led to a great deal of common approach in the way contracts are set up and administered. And I know that FEDIC has quite deliberately endeavoured to make their contracts as universal as possible, although they have a common law origin. They're certainly applied in many civil law jurisdictions as well. Back to you, David.
Just to pick up on that last point, it's an interesting one. I have been raising the question on several occasions with FEDIC people saying, your contracts are very widely used and they're very good, but they are very common law. Where is your civil law-based contract? And the answer seems to be there's no real call for one. Everybody is reasonably happy with the broad common law basis for the contract. But if I just mention one point in passing, which may be of interest, there are still 1 or 2 significant differences between civil law and common law approaches when you talk about substantive law. I know we're talking about procedural law. For example, when you talk about liquidated damages, which is still basically the Anglo-Saxon approach, which is found in the FIDIC forms. The civil law approach, which is the notion of a penalty, is still completely different. Very quickly, if I may, the liquidated damages approach is that the parties agree beforehand upon the amount that will be payable in terms of delay in particular, and that will be the amount, and if it is a penalty, then under English law it will be completely struck out. Now, the civil law approach, as typified by French law, is we don't really go for liquidated damages, we go for penalties. We accept the notion of a penalty, but we also accept the power of the court, i.e. in our case, the arbitrators, to modify that if the actual losses are very much lower, for example, than the actual amount. So there are still significant differences there, and that can lead to surprises in arbitration. And I've just had one in a recent case where, because of the different approaches of the arbitrators, they didn't quite pick up on what the position was under the applicable law. So yes, for me, perhaps there are more differences in the substantive law than in the procedural law. But just on the point of FIDIC, and I will cover this a little bit more when I come to ICC arbitration, since FIDIC has opted or proposed ICC arbitration since the very first cases, first contracts came out in 1957, then there are obviously a lot of ICC cases that deal with FIDIC issues. And the question is, where do you find out what the arbitrators have decided, because arbitration is confidential? There are a number of articles that deal with these, and I will mention these a little bit later on when I talk about arbitration. If we can move on a little bit with what I want to say, if I can come back to what I mentioned earlier on, yes, there is a large deal of consensus, but in the last couple of years, there's been what I might call a slight element of dissatisfaction and revolt from civil law lawyers who find the common law approach means that arbitrations, construction arbitrations, are far too long, far too expensive. And to a large extent, this is because of the excessive degree of document production and possibly the excessive use of witness evidence. And what has been produced is a set of rules called the Prague Rules. These were published in December 2018. They are called the Rules on the Efficient Conduct of Proceedings in International Arbitration. And they have been developed by essentially a set of 40 or 50 civil law practitioners. I see nobody from Vietnam on the list of contributors there, but they come from a wide range of civil law countries around the world. And they are really pushing the moves to reduce the time and cost of arbitration with steps that common law practitioners would find rather unusual, and in fact they would not want to follow at all. For example, the discouraging almost totally of a document production stage, such as that involving the Redfern schedule. There's also a greater a push for the tribunal to control more which witnesses actually give evidence. Obviously, if a party insists that a witness should give evidence at a hearing, that will be allowed. But there's a greater promotion of a power for the tribunal to control how many witnesses give evidence. A greater focus on the experts appointed by the tribunal instead of expert witnesses. And as we've already heard, expert witnesses are a fundamental part of many international arbitrations. All of this with a view to reduce the time and cost of arbitration proceedings. I bring this up because this has been something of a large stone thrown into the international arbitration pond. How effective these rules are going to be, how many people will want to take them up, remains to be seen. A lot of common law practitioners consider that they really go too far and will not be adopted, but this remains to be seen.
if I could just come back for a moment to the issue of the substantive law, you raised a very important point, David, in relation to the fact that there are significant differences. I think there's also perhaps a fundamental difference between them. That is that common law is judge-made law. Most of our common law is derived from judgments, and we still refer back to judgments that were made 150 years ago because some of it is still good law. Now, we are getting more legislation in our common law world that is covering things that in the past were derived solely from the common law, but there's still a great deal of law which is not codified the way it is in the civil law. And I believe that's the reason why common law construction contracts are in general much longer than civil law contracts, because the majority of what you need for a civil law contract is already there in the civil code. I think one of the effects of this, let's call it the additional complexity of the common law, the fact that we have to wade through all of these judgments and so forth, is, you might correct me if I'm wrong, David, I have the very strong impression that there are a lot more English construction lawyers than there would be French construction lawyers, for instance. And I suspect that that also has a bearing on the fact that international arbitration, there's perhaps a larger number of common law arbitrators than civil law arbitrators. And perhaps another reason why up to now, at least, the common law arbitrators have had an outsized impact on the profession. What are your thoughts about that?
I completely agree with you. The construction lawyer market in Paris is much smaller than the corresponding one in London. What are the reasons for this? It's very curious, because when you look around the world, you get the impression that the international construction business is very common law influenced in terms of the law, in terms of practice, in terms of project management. That's not just because of the UK influence, there's a lot of American influence, of course. But when you look at the about 200 countries, only 35 to 40 are common law countries. All the rest are, largely speaking, civil law based, and a lot of that civil law is based upon French law, which the French took out around the world in the 19th and the early parts of the 20th century. And as I understand, Vietnam still has a lot of influences of French law in its own legal system. But all the same, it is the common law that still rules the waves, as the British would say. It's a bit of a shame, because it leads to perhaps a very almost perfectionist way of dealing with matters. Everything has to be written down. Nothing can be left to the parties really to talk about between themselves. Everything has to be set out. And as you're saying, this comes back to the root being the nature of the legal system, I think, where since there is so, relatively speaking, little English construction law in terms of statutes, it is court-made law, and who knows what the judges will decide, so let's set it out in contracts which are very long. Whereas a lot of the principles of French construction law are part of the Civil Code, which goes back to 1804, written partly by Napoleon, and that the principles haven't changed that much. And it is the application of principles which takes place in civil law systems, opposed to extremely detailed rules under the common law system. So it's quite curious, the approach. There's just a related point I wanted to come on to. If you have a project and the applicable law is a common law system, say English law, does that mean you should choose an English law arbitrator or a highly experienced English construction professional as your arbitrator? It's an interesting question. And I wouldn't say it's always necessarily the right thing to do. I think it depends to some extent upon your position in the overall picture. If you're one of the parties, if you're the counsel for the parties, what are the specific issues that you're having to deal with in your case? Take it back, for example, to the issue of liquidated damages or delayed damages. It depends which side you're on. Are you the party which may have to pay, or are you seeking to recover? And depending on the strengths of your case, you might go for an arbitrator who's more inclined to follow perhaps a more civil law route than a strict common law route on the matter. But I think even though there are still these differences between the systems, my own view, generally speaking, it's very difficult to generalize, but is that what you need as an arbitrator is somebody who knows reasonably well both approaches, both common law and civil law approaches, when it comes to the law and to the procedures, as well as being somebody who has a good construction experience. And in particular, to come back to what Thomas said earlier on, someone who is a proactive manager of the case from day one. That's what everybody wants.
Donald, you want to comment on that?
Perhaps on a slightly different tack. We've talked about the difference between common law arbitrators and civil law arbitrators with a common law or civil law background, but I think there can also be problems with counsel from different backgrounds, and perhaps even from different common law countries, because the ethical rules that apply to counsel behaviour can be very different between, for instance, the United States and Australia. We don't have time to go into the details of it here, but this can certainly pose problems in an arbitration where, in one sense, it might not be a level playing field, because counsel acting for one side who are constrained by very strict ethical rules in terms of their interaction with witnesses, for instance, may be at a significant disadvantage to counsel for the other side who are under no such constraints.
Thank you. I think what is raised by David and Donald is very interesting and very important. And sometimes we are being somehow feel comfortable about the words like harmonization and the world is flat and everything that's come up together. But in reality, we still see the difference between the common law and civil law system, and each of them give a different way of education for their lawyers and also for their arbitrators, because lawyers and arbitrators are also mixed. And so David talked about the arbitrators, Donald talked about the lawyers. Personally, I have experience of appointing the arbitrator with common law background and with arbitrators that having the civil law background. And often there was a metaphor saying that the civil law background lawyers or arbitrators, they are more proactive. Like David said, they often ask questions and they really want to find the truth and about the case. And I feel personally I like that way, because I think they care, and I think that they show that they care about our case. Whereas for common law arbitrators, some, not all, they have to be so objective, and they would kind of refrain from asking questions. Either that would be seen as kind of bias, or it could be seen as the way of suggesting the direction to one of the parties, and they don't want to do that. And in one way, it's good because it gives the parties a level playing field. But on the other way, we don't really read the mind of the arbitrators, and we don't know whether he really understands or he doesn't understand the situation. Of course, we trust they are experts, but we sometimes we have to want the arbitrator to be reflective. Recently, I saw the common arbitrators, common law background arbitrators, they become more and more reflective. So, so I think from David, your position is that should have the arbitrators who are proactive, so that they can ask questions as is necessary. But you don't really support the idea of the BRAC rules, where they become too proactive in a way that they have their own view. They don't really need the produce documents and so on and so forth. Is that my understanding correct?
I'm not quite sure what I'd like to see these PRAG rules being used a bit. Frankly, I think there's a lot of positive elements in there because arbitrations just tend to go on for too long sometimes. And many arbitrators I find, they're not always perfectly prepared, and they don't want to take on deciding things when they don't know the facts fully. So if in doubt, they say, oh yes, I'll let him have another witness, I'll let him make an contribution, I'll let him have further document production request. So I think it is good with the idea that there's an initiative to help to promote a more proactive approach from arbitrators. But there's one aspect of this which for me really brings out this civil law, common law divide. If you look at the rules, I think it's Article 9, you will see that there's a provision which says that unless the parties disagree, and that's important, the arbitrators are empowered to give the parties a preliminary view on issues in the case. This is early on in the arbitration. And this is all with a view to assisting with settlement during the course of the procedure. Now, for me, this is very important. Clients are interested not in paying for the retirement funds of arbitrators, they're interested in making profit for their company, as we've already heard, and in cutting down the time and money of proceedings. What better way, if they have to go to arbitration, than have some initiative during the arbitration to try to get an idea of what the outcome might be, what the arbitrator is thinking. This is something which you find in some civil law systems. In Germany, this is widely accepted, a bit less so I've seen in France, but it's more of a civil law push. And in England, I think to a large extent, it would be recognized with a feeling of horror rather than anything else. Although, again, there have been initiatives recently, which haven't gone very far, I think, in this direction, because it's not just a matter of civil law or common law, it's a matter of what I would call common sense, which is what everything should be about. But for me, this is one of the interesting aspects of the difference between civil law and common law, which I look forward to see how it develops over the next few years.
If I can just add to that, I think, although I'm a common lawyer, I think we common lawyers, and particularly arbitrators, need to learn a lot more from the civil law arbitrators. And I was reflecting, I think it really comes back to the fundamental difference between, or another fundamental difference between the common law and the civil law system in terms of how a dispute is resolved in court, and which of course is then borrowed for arbitration. And that is, in the common law, the whole principle is that the dispute is run by the parties. The judge is merely there to decide on the dispute as it's been put forward by the parties. Whereas, as I understand it, in the civil law, it's actually the judge who controls the dispute. The judge is the one who seeks out the information that the judge requires to make a decision on the facts and the law. And the parties or the council are subsidiary to the requirements of the judge. And I think that fundamental difference is really behind the observations David made on the differences between civil law and common law arbitrators.
You're quite right, Donald. It's what is sometimes summarized as the inquisitorial approach as opposed to the adversarial approach. And that is a principle that underlines a lot of French civil procedure and, to some extent, the French arbitration law. Though what I would say is, in France, as in many other countries, judges are just too busy. They've got too much work. They haven't got the time to be that inquisitorial. So it is left to some extent in the hands of the parties to put together their case as fully as possible. And then it is presented to the judge, who will not have that much time to go into matters. And when it's a technical matter, he will hand that over to a court-appointed expert. And what is found, and what my colleagues in the office tell me, I don't really do French civil procedure, but is that once a technical matter goes into the hand of the expert, then that expert is effectively the judge of the technical issue. And it is not that often that the French judge will not simply rubber stamp the decision or the findings of the expert. But he becomes the inquisitor on the technical matters, and he has the time to do that. So it is still a fundamentally different approach, I must admit, as you mentioned.
Yeah, I agree with David and also Donald. I think that we have a question from Phước. He asked, if possible, should a party under civil law system in a dispute choose to settle the dispute at an arbitration operating under and using rules of common law or civil law? And then I asked him back, do you mean procedural rules or applicable law? And he say both. So I don't know if you got the question. I don't, but I think maybe you do. David?
So it could be the question of which law and which procedure you follow.
Yeah.
Frankly, I'm not going to fly a flag for civil law or common law. I'm going to fly a flag for a choice of a national law which is clear and well developed, so you know where you stand. That's for me, it's very important. I have done cases in many countries around the world, and in some cases the law is not that developed, which is not helpful to the parties, because if you can't advise the parties reasonably clearly on their legal rights and obligations, then that makes it difficult to proceed and it makes it difficult to settle. So if you've got a reasonably clear system of law, then that is a good way forward. When it comes to the actual procedure, what we find now, because of the UNCITRAL initiative that Donald mentioned, and to a large extent, many countries have very well-developed arbitration laws, so they've got good procedure. And then on top of that, you have all of these institutions who have very good sets of rules. And so while I've done a lot of ICC arbitration, and I will be talking about it shortly, I would be very happy to do an arbitration under the LCIA rules, the Singapore rules, the Hong Kong rules, and others, because they are good, clear sets of rules. You know where you stand, you know how to take things forward. And that's what you really need. So that would be my answer, I think.
Yeah. Donald?
I would concur with that. I think very important to have clear rules and to have a seat of arbitration where you know what, if you need support from the local courts, you know that it's going to be effective and efficient. And I mean, it's very interesting to see how in the past 20 years, how Singapore has become such a world leader in as a seat of arbitration, because they seem to have everything. They've got a very supportive judiciary. They've got very clear and modern rules, and they've got very good physical facilities for conducting arbitrations, and they've literally made it a real export earner because it is so well accepted around the world. I think, and obviously there are a number of other seats that offer similar sorts of advantages. But I think, as David said, very important to have clear rules that everyone understands, and I guess those ones that are widely used probably sort of speaks for their popularity at this point.
Yeah. I think, may I add is that, well, because we're talking about the construction disputes, so most of the construction contract is governed by the law of the host country where the employer is located. So if so we don't really have much choice. So either if the construction is in China, it's going to be governed by Chinese law. If construction is in Cambodia, it's going to be governed by Cambodian law, North Korean law, whatever, Vietnamese law. And then when it comes to arbitration, you have a choice whether to choose a civil law jurisdiction or a common law jurisdiction, whether you go to Singapore or you go to Stockholm, or you go to Paris or you go to London. So what would be your recommendation? So whether does it have to go hand in hand? For example, if you choose Vietnamese law, better go to Paris or better go to Stockholm rather than to Singapore, because Vietnamese law is a codified country. They are not suitable of the way of cross-examination and produce a document and way of interpretation of the contract, and then give the party the free hand to discuss and take it like 9 months, 10 months, 1 year, 2 years dispute. And maybe they think that Paris may be more helpful than Singapore, or they say, or it doesn't really matter. It could be Singapore, and it could be equally efficient and equally fast and so on, because the applicable law is already civil law. Yeah. So where would they go for arbitration or proceed or the venue or procedural rules?
Well, my view is that the exact location, if you've chosen any one of those and half a dozen others where the rules are very clear, where you have a supportive judiciary, I don't think it matters whether it's civil law or common law. I think the more fundamental and important choice in one sense is to get the right arbitral panel. It's the choice of arbitrators that ultimately is going to be more significant than which particular jurisdiction. You can have ICC arbitration in Singapore, you can have ICC arbitration in Paris. In my view, I don't think that the location of the seat is all that important as long as you've got a supportive judiciary and clear rules.
Yeah, thank you. David?
Well, Dominic, Donald has just stolen a part of my next presentation, so I agree completely with what he says. For me, I completely agree. It doesn't really matter. A decent set of clear rules and good international rules are neither too civil law or too common law. You don't really find expressions like cross-examination in rules anymore. They provide more general framework, and it's there for the arbitrators and the parties to sort out what they want to do. And the important thing, almost more important than the arbitral rules, is the quality and the approach of the arbitrator. I'm not going to say any more, otherwise I'll have nothing to say in my next presentation.
Yes, thank you very much, David and Donald. So we close a very interesting topic about common law and civil law, and I really like the conclusion of Donald, his own comeback to the panel and the arbitrators.
Pauline, can you share your videos for us? First speech will be the solution of construction dispute at the Singapore International Arbitration Center. Hello, Pauline.
Hi, can you hear me?
Yes, we can hear you well.
All right. Okay, just
Okay.
let me share my screen.
Yeah.
Okay. Right. So first of all, thank you so much for having me. Just by way of a quick introduction, my name is Pauline. I am a counsel at the SIAC. I'm with the Secretariat, and what I do is case administration. I have administered over 100 cases under the various versions of the SIAC rules. And what I hope to do today is to give you an idea how a construction dispute can be resolved at the SIAC in the most time and cost efficient manner. I think SIAC, like the ICC, is also an arbitration institution. And so many of the roles played by the ICC are also the roles that SIAC played. David has given a very good overview of that, so I will not repeat. But before we go further, I feel that it probably would be helpful to just give a very brief overview of SIAC. As an arbitration institution, we started in 1991 with just 2 cases, but right now we are third in the world after the ICC and LCIA. And our caseload has really grown over the years. We have, last year received a record-breaking number of cases, new cases. We have received 479 cases. As an institution, we have also become very international. More than 80% of our cases involve parties from a different jurisdiction, and our parties come from as many as 59 jurisdictions. And we owe this really firstly to, I'd say, our rules, which are very progressive. We are, for example, the first commercial arbitration institution to have a mechanism for early dismissal of cases. We'll look at that in more detail later. And you've had the privilege earlier of hearing from our Deputy Registrar, Kevin Nash, and who's been behind the drafting and revision of some of these rules. And we also have a proven track record of enforcement. Now, Vietnam, as a jurisdiction, has always been very important to SIAC. And you can see here that, we are seeing more and more cases involving Vietnamese parties, and the cases are growing in complexity. They involve a higher amount in dispute. If you look at 2019, for example, they are in the billions. And these are SIAC's top 10 users last year. I think looking at this graph here, you will immediately see that the top contracting partners of Vietnam, for example, Korea and Japan, are amongst SIAC's top 10 users. And I feel that it's extremely wonderful that we are looking at construction disputes today, because in 2019, construction disputes make up 46% of our Vietnamese cases. And so the point I want to make is that when it comes to Vietnam, what we offer at the SIAC is integrity. We offer expertise, and I would say really a sense of familiarity with the business and people in Vietnam. And on this note, I also want to share with you that we are very pleased to have on our SIAC panel a set of arbitrators who are familiar with Vietnam and Vietnam laws, 2 of which have indicated their willingness to be appointed as emergency arbitrator if required. And I think these are very common names in Vietnam that you're very familiar with. You've heard from Dr. Leonard, for example, earlier. And we also have a Vietnamese SIAC court member. And so it is a question that we get asked very often is, whether it's possible to have an arbitration involving a Vietnamese claimant, Vietnamese respondent, Vietnamese lawyers representing the parties in Vietnamese language with a hearing in Vietnam under the SIAC rules. And the answer is yes, that is the kind of flexibility that we offer at SIAC and under the SIAC rules. Now, let's take a closer look at the life cycle of a typical arbitration, including construction arbitration at the SIAC. Now, arbitration doesn't really begin from commencement. It does start very much earlier before that. In fact, the drafting of the arbitration agreement, and to have SIAC administer your arbitration to bring your case under the SIAC rules, parties would have to agree to use SIAC and our rules in their contract or agreement. And to do that, parties can simply include in their contract or agreement the SIAC model clause. We have a couple of different model clauses on our website. We have the standard SIAC clause. We see that very often in many contracts. We also have the expedited procedure model clause for parties who can agree at the time of contracting that they want to use the SIAC fast track procedure. And then we also have the ARB-MED-ARB clause. And this is for parties who want, at the very get-go, know and want to integrate mediation into their arbitration. These are all online on our website. And one advantage with arbitrating at the SIAC is that there is a myriad of provisions that parties can make use at different stages. I've prepared this overview here to really help you see that. And parties can make use of all these different provisions to really help them control time and cost. And today, I think we'll look at these different provisions and how each of them can be used effectively to help parties control time and costs in the context of construction arbitration. Now we'll look first at expedited procedure. I think construction-related disputes can be quite complex, but not all the time. You can have a very simple sale and purchase contract for materials, or a contract for provision of workers. And the SIAC expedited procedure is great, it's excellent for that, for simple disputes like that, because under the expedited procedure, your matter gets referred to a sole arbitrator and you get the award issued within 6 months. Now, SIAC is a bit different from other institutions in the sense that the expedited procedure under SIAC is by application. And when we look at this, there is really a whole spectrum of it. On the one end, you have institutions like Stockholm, where the expedited procedure is contained in different set of rules. And that's all good and fine, but you could get into to jurisdictional issues as to which set of rules would be applicable. And then you would also need to know at the time you enter into the contract whether this is a case which would be appropriate to go under the expedited procedure. And sometimes this can be difficult because quantum does not always correlate with complexity. And then on the other end, you have like the ICC, where it is automatic the moment your sum in dispute is under a particular amount, if I'm not wrong, $2 million US, and then it goes under the expedited procedure. And somewhere in the middle, you have HKIC and SIAC, where the provision is contained in main set of rules and it's by application. The advantage of that is that you get all the tricks from one main set of rules, and you get at the SIAC, you get the SIAC precedent to look at your case and decide whether it's one that's suitable to go under the fast track procedure. Now, moving on to consolidation and joinder. Many institutions have this in their rules, and I think this is critical, especially for complex construction projects where your dispute will normally involve multiple parties. What have you, the main contractor, the subcontractor, you have your engineers and your architects, and you'll find that your dispute most of the time will not arise from a single contract, but multiple contracts. You have the main contract and then you have subcontracts. So in the past, you would have to commence multiple arbitrations under these different contracts and against all these different parties. And the downside very clearly is that it can be very costly. You may get conflicting decisions, but with the consolidation and joinder provision, you really bring all the parties together and you have all the disputes arising out of all these various contracts decided by a single tribunal. And the cost of the arbitration will be calculated based on the aggregate sum of all these disputes. So that's good. And an advantage of the SIAC consolidation provision, how it's slightly different from other institutions, is that it allows a broad identity of parties. And when I say this, I mean that the parties of the different arbitrations, they don't have to be the same. And again, this is very critical for some multi-party, multi-jurisdictional disputes. You can have, for example, in arbitration, the first arbitration, claimant A, respondent A, and then you can have in the second arbitration, claimant A, respondent B, and then you can have in the third arbitration, claimant A, respondent A, B, C. And you can, under the SIAC rules, consolidate all of these arbitrations. For joinder at the SIAC, it can be made by a non-party. The other thing I wanted to highlight for joinder and consolidation applications is that it can, under the SIAC rules, happen before or after the constitution of the tribunal. There are obviously tactical reasons why you want to do one or the other, particularly, in the case of pre-constitution. I think one advantage is that by bringing all the parties together, either by way of consolidation or bringing in a new party by way of joinder, all of the parties who are interested then would be entitled to participate in the constitution of the tribunal, which again is critical because it can lead to issues of enforcement of award, and this is all under the SIAC rules without prejudice to the tribunal's decision later to relook at this when it's constituted. Now, the other thing I wanted to talk about is emergency arbitration, and at the SIAC, really, there is a, I would say, culture of emergency arbitration because we've done so many of them, and we keep honing and refining our skills. Now, in the context of construction disputes, we have seen it used, in various scenarios. We have seen it used to prevent certain bank guarantees, which you find very often in construction disputes, from being enforced. And I think even in construction disputes, you can have a situation of dissipation of assets, and this is where the emergency arbitration provision would be very useful. And one advantage of the SIAC EA provision is that you can make an application on a Friday after close of business, have the emergency arbitrator appointed on by Saturday, have your interim order issued to preserve status quo pending the emergency arbitration hearing, and then have the award, the emergency arbitrator award, issued by Monday. We have also, I think the emergency arbitration provision have also been used as a strategic tool at the institution. We have seen how the emergency arbitration can sometimes, result in the early settlement of the dispute. Now, I spoke of early dismissal earlier, and I mentioned how SIAC is the first major international commercial arbitration institution to have this in our rules. Again, you would find, or rather we do find that parties or users do find exit decisions to be useful. We have seen parties cite them in their submissions. The tribunal refers to them sometimes, but they're not binding. We have seen the early dismissal provision used in very creative ways. For example, to strike out the respondent's defense that is unable to pay deposits in an application for reimbursement of deposits under the SIAC rules. And then in the context of construction disputes, if you have a straightforward case of non-payment of debt, I think the early dismissal provision can be really useful to help you get a resolution or the settlement of the dispute within 2 months. The last provision that I want to look at is the ARP-MED-ARP protocol. I want to look at this because I think, especially in the context of construction, I think arbitration is not always the best form of dispute resolution. Sometimes mediation can be better, especially when you see that the parties are prepared to come to some form of amicable settlement. And sometimes you want to have both arbitration and mediation. And at the SIAC, this is completely possible and it's doable under the AMA protocol, ARP-MED-ARP protocol, which really allows the parties to try to mediate their disputes before arbitration. So what would happen is parties would commence their arbitration at the AC, and an arbitrator would be appointed, after which the arbitration would be stayed and referred to mediation at the SIMC, the Singapore International Mediation Center. If the parties are able to come to an amicable settlement, what will happen then is that the settlement will be recorded in the form of an award by the arbitrator that's already been appointed. And an advantage of this is that if the parties are, for some reason, unable to come to a settlement, then they can immediately proceed with arbitration before the arbitrator has already been appointed. I think David spoke of scrutiny earlier, and that is also a value-added service that we offer at the SIAC. Awards would have to be scrutinized before they can be so awards would have to be scrutinized before they can be issued by the SIAC, and what the purpose of this is really to enhance the enforcement of an award, because what you really don't want is to, at the end of the day, get a paper judgment. I think the award has to sort of act like an ATM card, where you go to the ATM and you should be able to convert it into cash and not just get a paper judgment. And so that's what we do at the SIAC. At the end of the arbitration, we also scrutinize awards. Now, one final thing I thought would be very important for me to touch on would be cost. And at the SIAC, we use the ad valorem system. What this means is that cost of the arbitration does not depend on the hours spent, but it's pegged on the sum in dispute. And the advantage of this is that it gives you certainty. It lets you know what your maximum exposure is at the very get-go. And I think this is particularly, again, important for construction disputes, especially complex construction disputes where the proceedings can sometimes be very protracted. And at the end of the arbitration, we have the cost determination process. This is done by the registrar, and what it means is that what you're bearing is really just a proportion of the maximum cost of the arbitration. So what do we look at when we determine what the actual cost of the arbitration is? We look at the amount of work done by the tribunal. We look at the hours spent. We look at the complexity of the case, and obviously, if a case is settled very early, the tribunal will not be paid the maximum fees. What you don't want an institution to do is really one that operates mechanically and look purely at milestones. We don't do that. I think what I want to highlight here is that at the SIAC, we are copied on all of the correspondences. And so if required, the registrar could always, when determining the cost of the arbitration, go into the case folder, look at what has actually happened in the case to see how much a tribunal should be paid. So the tribunal can say that it has, for example, expended 100 hours on the case, and then but the case somehow got settled within 2 months, and this looks a bit funny, right? So, but the registrar can go into the case folder and see if this is really justified. So what you have at the SIAC is really a sanity check by the registrar, so you can be assured that you only pay for the work that actually has been performed by the arbitrator. And because it's pegged on the sum in dispute and not the number of hours spent, very obviously the arbitrators are incentivized to work very quickly, so you won't have a situation where the arbitration goes on for 4 to 5 years with spiraling costs and time. Now, we have been asked a lot, but what if the parties and the tribunal can somehow agree to have a different scheme of fee? I think that is again a flexibility that we offer at SIAC. If for some reason the parties and the tribunal would want to go under the hourly rate, they can do that. But from what we observe, the preference seems to be to have the ad valorem system, where you know at the get-go how much what your exposure is. So I have included here a link which will take you to the SIAC fee calculator. So if you have sight of, or if you know what the amount in dispute is, what you can do is to use this calculator to help you get an estimate of what the total cost of the arbitration, the maximum cost that you would have to bear should you decide to go for arbitration. And that really, yeah. And so we've been talking about cost. We've been talking about, you know, the best way to save time and cost. And this really is just to give you an overview of the average amount of time taken at the SIAC for an arbitration to start and finish, and the average time taken, the cost incurred for an arbitration. So we have various offices worldwide, but the case management office is actually in Singapore. That's where all the action happens, and that really brings me to the end of my presentation, and I guess that concludes it.
Yeah, thank you very much, Pauline. There is some question waiting for you on the chat, but now I would like to invite Mr. Phan Trọng Đạt from Vietnam International Arbitration Center. That please start.
Thank you, Mr. Nguyen. Good afternoon, everyone. Can you hear me? So I'll take a few seconds to share my PowerPoint.
A little bit louder, please.
Yeah. Can you hear me?
Yeah, well, yeah, thank you.
Okay, I'd like to a few seconds to share the PowerPoint. Have you seen?
We can see your screen. Okay, your slide now.
You can see. Okay, thank you. That's good. Well, now I'm very pleased to show you and foreign friends some of the practice of construction dispute resolution at VAC. Actually, we'll give you the overall picture of construction disputes in Vietnam. And you see from the chart here, we've done the survey with the Vietnam Association of Contractors Construction. And you see the method of dispute resolution used by the contractors. 33% prefer negotiation. And arbitration we are talking about now is only 8%. And the fact is that in Vietnam, the use of ADR is increasing, and VAC and other institutions have been trying to promote ADR in Vietnam for all the businesses, including construction ones. So for construction enterprises, they consider on selecting arbitration, for timing is a 58% consider that arbitration save their time, and also 54% for cost. And you see the enforceable award and the rate of success accounts for 41% and 36% respectively. So all the characteristics of ADR, including arbitration, are absorbed in the survey, and the businesses just understand the benefits of ADR when they select arbitration. At VAC, from the period of 1993 until end of May this year, we have the rate of 14% of construction disputes. So 14% is not a great deal. It ranks the second after sales dispute. And you see on the figure we show here, the highest dispute value is around $6,000 billion, equivalent to some 250 million US dollars. It's not much compared with those at SIAC and ICC that we've seen. But you know that in Vietnam, these are huge, and the fact is that you see the later on I show this, but you see here the fact is that the feature of dispute contract at our center, just number 2 is applying international regulations such as FIDIC, but you see it's very, very few cases using FIDIC. The majority of cases just normal construction contracts, not using the FIDIC form. And that's why I explained earlier, the value in dispute is not high, well, it's not high enough. But for the cases involving FIDIC form, then the contract value is very high, and then the value in dispute is high too. We see here some arbitrators at VAC. By this photo, we would like to inform that in our panel of arbitrator, we have prepared several top construction experts in Vietnam for Vietnamese party to select. We also have some foreign ones for you as foreigner or FDI companies in Vietnam to select. Another notice is that besides selecting arbitrators within the list of arbitrator of VIAC, you can select any other expert outside that list. You can select also foreign arbitrator outside, and that's the practice for several big construction cases at VAC, where a party, particularly the foreign party or the FDI party, have selected a foreign arbitrator outside the list of VIAC arbitrator. Now, first, back to the arbitrator. We just a few days ago, we organized another construction seminar, and the question of applicable law was asked. And from the presentation of a previous speaker, we also talked about the law. And here in Vietnam, for the construction in Vietnam, you all know that there are mandatory rules and laws that apply. By that I mean, for dispute involving a foreign party, you can select foreign law. But be careful that when you have a dispute with a Vietnamese party about construction work in Vietnam, then you should consider selecting a Vietnamese expert as an arbitrator who understand all the rules and laws of construction in Vietnam, and who will help the tribunal be more efficient in resolving such dispute. Otherwise, if there's no Vietnamese at all, then we feel that it would be there would be some difficulties for the tribunal to understand the situation in Vietnam and to make the very efficient award, enforceable award. Back again, we have here some features of disputed contracts at VIAC. We describe something about FIDIC, and here some other features such as the dispute or the contracts are participated by more than one contractors, also including foreign contractors, and it applies several design standards from different countries, and also having employers transferred during the implementation. Now I would like to focus a little bit on the fourth point. You have employer transferred. That means the leaders or the CEO of such companies, when they sign the contract with you, the construction contract with you is another one, but when there's a dispute, that's another one, and when at the arbitration process, then another one too. We, like in other jurisdiction, we've seen some frequent dispute issues disputes on employers, delay on consultant actions, also extension of completion time, warranty payment, material quality, and also changes in policy from the Vietnam authority. Well, actually, for the changes in policies is a concern from the foreign communities, but well, so far we see that the stability of laws in Vietnam is getting better and better. Talking about the law, we talked earlier in Vietnam. We have a lot of laws governing for construction works. We have the Civil Procedural Court. Also, for arbitration, we have the Commercial Arbitration Law 2010, and law on construction and other legal documents. And in Vietnam, for ADR, we just have mediation. The mediation is legalized by the decree number 22 in 2017. And at the final slide, I would like to show you some good signal of using mediation in Vietnam. And it's highly recommended for you to use mediation in Vietnam for construction disputes. Well, for the tips here, it's not new for you when you consider requesting, just sending a request for arbitration against the respondent. The first thing you need to have a careful pre-proceeding preparation. So the selection of arbitrator, involve lawyers and also expert witness, and of course, appropriate strategy for complicated issues. Yes, finally, here we have the figures for you for mediation. This is mediation. And you see the number 5. Number 5 stands for the 5 successful mediation cases. All the 5 cases have disputes on construction disputes. And you see, for such reason, then the value in dispute, again, very high. It's around more than 40 million US dollar. And of course, we can have 3 cases also in English. And mediators in Vietnam, they are not merely domestic mediator. We have some more than 70 skilled mediators certified by Center for Effective Dispute Resolution of the UK. And then that's why we are just very confident that when you have construction disputes, besides thinking of arbitration, you can think of mediation at VMC created by Vietnam International Arbitration Center. So finally, this is my last words on this. Construction, you see, construction in Vietnam. Vietnam is now a developing country, and if you visit Vietnam, you see several construction works. Both you see for the like bridges, like metro, or also for highways, everything's ready. And for the construction, it seems that it involves foreign party a lot, at least FDI party. So when we have the survey for FDI companies in Vietnam, and 92% of the respondents say no to the court. They all prefer mediation or arbitration. So that's good news, and we hope that VIAC and VMC will serve your demand very well now and in the future. Thank you for listening.
Thank you very much, Mr. Das. So now we have finished for all of the presentation, and now it's come for the people for the floor to ask the question. We have one question from Facebook, Mr. Bảo Trí. but sorry that the speaker, Pauline, he already left. So, Chi, do you still acting? Or any question from the participant? Sorry, anh chị ơi, các anh chị có ai có câu hỏi nào thì xin đặt ở đấy luôn, thì có thể tôi sẽ dịch dịch trước. Xin làm đặt câu hỏi trực tiếp trên Zoom chat hoặc là hỏi trực tiếp ở đây luôn. Please turn on your camera and if you have question, please share your screen. Hello. Maybe after 3 hours, people become tired. We have one question from about cheese. Here he mentioned that you can see on the chat room, although Pauline not here, but I'm looking for to that and also to David regarding the enforceable date. The awards is the final arbitral awards. So the question from Tree is, should we mention about the effective date in the arbitral awards? Mr. Dat and David, can you give your opinion in the question on the chat? Oh, that unmute, please.
Thank you, John. I'm not quite sure if can you hear me? Is that okay?
Yeah, we can hear you.
I'm not quite sure if I fully understand the question, which I understand a bit about mentioning an effective date in the award. I think any award needs to make it very clear as to the specific date from which any financial award in particular is to take effect. If that's what it means. Obviously, if the decision of the arbitrator is that a certain amount should have been paid, say at some time in 2017, then that date needs to be specified. No doubt there will be a claim for interest in relation to that, and the award should also state or decide on the claim as to the amount of interest and perhaps give a calculation on a monthly basis or whatever from the date on which it was payable. There are awards which say interest calculated from the date of when amount was due onto the date of the award, and awards might also state that the amount payable is payable immediately, and interest will continue to mount up to accrue at a daily or a weekly rate of, and it might specify the amount until the amount is actually paid. I think that is what arbitrators should be doing when it comes to financial awards. I'm not too sure if there are other aspects of that also need to be addressed.
Yeah, maybe that can contribute from the law of Vietnam. Yeah.
Actually, from the law and practice of Vietnam arbitration, in the award, there must be the date that the award is made. And there's always the date, that date on the award.
I see.
Oh, yes, absolutely. Yes, absolutely. I completely agree.
Hello. Hello. We're looking for more questions, please. We have about 9 minutes left for the participants to give us the question. Balas?
May I add something?
Yeah, please.
Yeah, if we are waiting for question, but we would like, just because here we see that we are serving foreign participants. So one thing we need to verify very clearly that FDI company in Vietnam, even 100% capital of foreign direct investment in Vietnam, under Vietnamese law, is a Vietnamese company, Vietnamese entity. So for that, if arbitration at VIAC between an FDI company and a Vietnamese company, or even between two FDI companies, Vietnamese law must be used. you cannot agree on foreign law. If you agree on foreign law, the tribunal will invalidate such agreement and apply Vietnamese law. That's just one takeaway for FDI companies. Thank you.
I have one question to that also, because between two Vietnam entities is not good, but in case on company in Bahamas with the construction project in Vietnam, so do you have any recommendation because for the applicable law that can you?
Yeah. So at VIAC, by law and practice, when the dispute involving a foreign party like a Bahamas party, then the party can agree on foreign law. That's the choice. Despite that, I personally recommend party involving construction contracts and construction disputes that they should agree on Vietnamese law. As I said earlier, for Vietnamese law, for construction, it involves a lot of mandatory laws and rules in Vietnam where the site exists. So the parties should consider Vietnamese law. But for other fields, such as sales of goods, international trade, you can agree on other. For the UK law or French law, it works well. But for construction contracts, you should highly consider Vietnamese law. You can also agree on foreign law. But finally, the tribunal will have to take care of and use several mandatory rules and laws of Vietnam because of it's a construction dispute.
Thank you very much.
Could I just follow up on that, if it's possible? It's a point I didn't make earlier on. I completely agree with that comment. And I find this particularly in civil law countries where there is a lot of mandatory construction law. And it becomes quite difficult. There are some parties will say, okay, I'm going to this country, I know there are those things, but I still want a law that I know and respect. So you've got a lot of problems of trying to work out how the two laws will work together. But I agree with you, in many countries, the right choice of applicable law is the law of the country. But then again, in civil law countries, sometimes you have problems working out how that law interfaces with the law, the provisions of the contract. Again, coming back to FIDIC, I've had a lot of problems in one or two countries in Southeast Europe, which have a lot of mandatory construction law, which is completely inconsistent with FIDIC provisions. And so you have a lot of problems that, for example, for takeover, you have to go through the FIDIC procedure, but then afterwards you have to go through the whole national procedure. And that, I'm afraid to say, has led to arbitrations. So there are lots of issues like this which you have to look at very carefully. But in principle, I quite agree that it is sensible to consider as much using the law of the country where you have a project.
Could I just make a contribution there? I think, as David points out, there's a lot of mandatory law involved. I mean, the minute you have a construction project in any country, there will be a lot of local laws that will apply automatically. They're mandatory law, things like labour laws, laws relating to property, and so forth. But we needed to distinguish from what the parties have selected as the law of the contract, which may or may not be the same as the law of the country. And that can, of course, give rise to significant issues. And then when you come to looking at issues of dispute resolution, there can be different laws that apply there as well. The law of the seat of arbitration, for instance, may be different to the law of the country where the site is located, or the governing law of the contract. And it's an issue that needs the parties need to be aware of. If I could stress that it's always better for the parties to specifically nominate the law of the contract rather than leaving it open, because that can lead to all sorts of problems under conflict of laws and can be an expensive issue to resolve in ultimate dispute resolution. The subtext is be aware that there may be more than one set of laws that apply to different aspects of the arrangement between the parties.
Thank you, Donald. There is one question from floor on the chat. Let's add this. Should wonder if the party may agree on the law of foreign law for the matter that the Vietnamese law have not yet covered. So do you have to us to answer?
As I said, for dispute involving a foreign party, the Vietnamese law on arbitration allows the party to select foreign law. So that's the law. The law allows the party to select. But whether the party select foreign law and which foreign law is the question, the issue of the parties. And well, it also, I think it's also the work of lawyers who help the party when they negotiate the contract, where to see the differences, if any, between the provisions in local law and the international practice, such as FIDIC, and the probability, the possibility of the risk possibility when dispute arise. So that's what I can contribute.
Thank you.
Could I make a slight plug here for a book which has been published by Routledge in Formal Law on the application of FIDIC contracts in a number of different jurisdictions around the world. And I edited that book. I was assisted by some very skilled construction lawyers from around the world. For instance, David Brown and one of his colleagues wrote the chapter on the application of FIDIC contracts in France. That book has been well received, and we're now working on a series of another books to try and include the various jurisdictions that weren't covered. Because there are so many jurisdictions around the world, there's probably going to be something like 4 separate books, the first of which will deal with the Asia Pacific. And our host, Trung, and several of his colleagues are cooperating to write the chapter on Vietnam in this book, which will be called, I think it's the application of FIDIC contracts in the Asia Pacific. And the specific aim of this book is to highlight the issues that arise in a specific jurisdiction, what needs to be done to actually apply a FIDIC contract, what you need to put in the particular conditions to take account of the specific law of Vietnam. If your project is in Vietnam, then there's a lot of mandatory law which will apply. Whatever the law, governing law of the contract you've selected, there will be a lot of mandatory Vietnam law that will apply. And one of the tasks that Trung and his colleagues have before them, which they probably don't realise how large a task this is to identify the legislation in your country that applies to construction contracts. Having written the chapter for Australia several years ago, it is not a trivial exercise, which I'm sure David would agree with, even though perhaps the civil law system in a unitary country like France is a bit easier than Australia, but it's not a trivial exercise in any country because of the complexity of construction contracts and the large number of laws that apply. You know, think about things like labour, environment, health and safety, etc., etc. I think it's a very worthwhile exercise, and I'm very grateful for Trung and his colleagues for contributing working on the chapter for Vietnam.
Yeah, thank you, Donna, for introduction. Right now, I am Mr. Lê Hung from CNC Control, and Mr. Dr. Nguyễn Thị Hoa from Ho Chi Minh City University of Law. He helps say drafting a chapter on application of FIDI contract in Vietnam right now. With support from Donna. Yeah. Okay, we are looking for more questions from the participant. In fact, already 4 minutes over time, but if you have any question, please give to us. Welcome any question. If no question, hello. If no question, maybe I would like to ask participant to turn on the video, the camera, and just how to say, and also that I would like to give you some words to celebrate the Vietnam Idea Week. Yes, our event will be the very last one for Idea Week for this year. Yeah.
Xin phép được nói tiếng Việt ạ. Tại vì vâng, thấy rằng là còn khoảng hơn 50 người đang theo dõi ở đây thì đa phần là người Việt Nam, thì tôi rất là cảm kích sự theo dõi của các anh các chị ở đây, không thấy mặt nhưng mà chỉ thấy số thôi. Thì thực ra cả một tuần qua thì Trung tâm Trọng tài Quốc tế Việt Nam với sáng kiến từ trung tâm và từ các chuyên gia và đã hợp tác với rất nhiều tổ chức khoảng hơn 20 đối tác khác nhau để tổ chức đến 11 cái hoạt động, và đây là hoạt động 11 hoạt động cuối cùng, và tôi lại là người nói cuối cùng của cái hoạt động cuối cùng này, thì cũng không biết nói gì hơn là thực sự là cảm ơn tất cả các cá nhân và tổ chức đã đồng hành, đã giúp đỡ, đã tham dự, đã lắng nghe, đã bình luận, đã khen, đã chê để chúng tôi tổ chức xong, hoàn thành nhiệm vụ. Với tư cách của chúng tôi là hoàn thành nhiệm vụ, nhưng mà với ý nghĩa cộng đồng thì chúng tôi thấy rằng là đã có khoảng là hơn 1.000 người tham dự các sự kiện trực tiếp và khoảng trên 20.000 người là theo dõi các sự kiện qua mạng như thế này. Thì cả cái tuần lễ về trọng tài hòa giải Việt Nam 2020 lần đầu tiên được tổ chức tại Việt Nam đấy ạ, của năm nay, thì trong bối cảnh Covid nữa đấy, trong bối cảnh là Covid thế này thì đã với cái mục đích là để nâng cao nhận thức về phương thức hòa giải và trọng tài tại Việt Nam, và chúng tôi cũng có thể thấy rằng là cái mục đích đấy đã đạt được. Và cái mong muốn của chúng tôi là có thể là thường niên sẽ có những cái tuần lễ trọng tài và hòa giải, và nếu mà là thực hiện vào năm sau đấy ạ, thì rất là mong muốn sẽ có sự tham gia nhiều hơn nữa của các trung tâm trọng tài, các trung tâm hòa giải quốc tế, các chuyên gia quốc tế nước ngoài như ông Donner, rồi ông David, vì các lý do khác nhau mà chưa tới được Việt Nam. Chứ tôi cũng hiểu là nếu mà với chương trình như này mà không bởi Covid thì anh Nam Trung cũng có thể đã mời các chuyên gia nước ngoài đến Việt Nam chia sẻ kinh nghiệm, và nó cũng sẽ là thực hơn nữa, nó sẽ là thiết thực hơn nữa. Thì chúng tôi cũng không biết nói gì hơn là xin phép là khép lại cái tuần lễ trọng tài và hòa giải Việt Nam năm 2020 tại đây. Và đây là sự mở đầu thôi. Chúng tôi đã được ghi nhận từ cộng đồng và được sự ủng hộ của các cơ quan quản lý nhà nước và các cơ quan hữu quan khác và các giới truyền thông. Anh chị em rất là ủng hộ, và chúng tôi cũng sẽ có thêm động lực để tiếp tục tổ chức các cái sự kiện tiếp theo nữa, để một lần nữa là nâng cao nhận thức về phương thức trọng tài và hòa giải, và quan trọng hơn là đóng góp một cách thực tiễn các kinh nghiệm, các bài học kinh nghiệm, các cách thức để sử dụng hòa giải và trọng tài và đi vào sâu từng lĩnh vực, như các lĩnh vực như xây dựng đây, để doanh nghiệp chúng ta thì ngày càng tránh được các rủi ro tranh chấp, và ngay khi đã có tranh chấp rồi thì quản trị cái tranh chấp đó, giải quyết cái tranh chấp của doanh nghiệp thật là hiệu quả và thành công. Thì cũng xin gửi lời chào tới các diễn giả rất là đáng mến của phiên hôm nay, và chào quý vị khán giả, và xin chào tất cả mọi người. Xin trân trọng cảm ơn.
Yes, thank you very much for today. Everyone, please just turn on your camera, and especially thank to David, Donan, Dr. Nate, Chin, and everyone for still waiting until now. Yes, just want to say goodbye. Thank you very much, and goodbye.
Goodbye. Thank you.
Bye. Cảm ơn anh Khang. Okay. And...
Trung ơi, cảm ơn Trung.
Dạ, cảm ơn chị nhé.
Very good. Rồi.
Cảm ơn chị.
Thành công rồi.
Ok, em gọi WhatsApp.
Hello Nghĩa, bye.
Bye.